The chief task of the federal defender, as they see it and as they consult with their client, will probably be to avoid the death penalty. The Department of Justice has to make a decision that they're going to seek the death penalty. That decision has not been made, or at least has not been publicly disclosed, and frankly, I don't think it will be until the investigation is more mature and is further along. If the government decides to seek the death penalty, that will obviously complicate proceedings in that there will be two trials. There's a bifurcated trial. There's a trial on guilt or innocent, assuming the defendant does not plead guilty, and then there's a separate trial, if you will, on the penalty phase. If he's convicted federally and receives an appropriate sentence, and having in mind that Massachusetts does not have the death penalty, the maximum sentence would be life imprisonment. It would be up to the district attorney whether they wanted to proceed. If he was convicted in federal court and received either life imprisonment or the death penalty, the DA would have to decide, is it really worth their resources to have a separate trial with the same outcome. The lawyer for the defendant will argue that he was under the control of the older brother, and that although that may not serve as a defense to the substantive charges, in other words, you can't claim as a defense, the brother made me do it, or I was under the influence, it could have a bearing on the penalty phase. And it could well be something that the jury, the government in the first instance, but perhaps the jury will take into account, which would mitigate the severity of the penalty, having in mind his age and having in mind what will be claimed to be the influence by the older brother. The fact that they apparently questioned him without giving him Miranda warnings, that the government considers its case fairly strong without the benefit of any statements that he might make now. In other words, if you fail to give the warnings and the defendant makes a statement, the remedy typically is you can't then introduce that statement into court. But the government probably thinks they don't need those statements. They probably have enough already. You know, this has been a point of some controversy. There are some members of the public and certainly some members of Congress that would prefer that all cases that are like this involving terrorism be tried in a military tribunal. It's unclear to me whether, when the defendant is an American citizen, the acts of terrorism take place on American soil, whether there is a legal justification for going the military tribunal route. And I think here also what's involved is that the U.S. courts, the criminal courts, in my view, have proven themselves quite effective and quite able to handle terrorism cases of all kinds.